Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Some of you have no doubt seen the video that was released today where I talk about this case, and I point out that Jennifer Crumbley is being charged with negligent homicide, and why I think there might be a lot of valid reasons to charge her with negligent homicide. But that was before I heard some of the evidence that came in yesterday, and I think that bears another look at this, and to sort of look at it from the standpoint of the defense. And I've been pretty critical of the defense. I think I've said I thought the defendant was overmatched, but a lot of times, particularly when I'm working on these trials, I look at this and I think, boy, I wouldn't do that. Why did they do that? And unfortunately, that's an unfair comparison. And the reason it's an unfair comparison is because the state always goes first. All of the bad evidence always comes in first. And as a result, somebody can look overmatched just because they are trying very hard to defend their client, and the evidence is certainly against them. And that's certainly been the way this has gone. But yesterday, there were some changes in the way I view this trial, and I now think that there is at least a possibility that she could get an acquittal here, but it's going to depend a great deal on the advocacy efforts of the defense counsel. So why do I say that? Because I know I've said it before, but trials are not won in the courtroom. They're won well before you ever get to the courtroom. They're won in civil cases, in discovery motions, motions to compel, and that sort of thing. And for the prosecution, they're won in good police work, in good witness statements. And for the defense, they're won in good work in pretrial hearings. And the reason for that is because a pretrial hearing gives you the opportunity to learn what a witness is going to say at trial, and you can develop impeaching evidence at that pretrial hearing. And in this case, we had some interesting testimony from the school counselor 1 year before this case ever went to trial. And here's what some of that testimony was.
You did not ask if you could see Ethan's journal, correct?
Correct.
And you're aware now that the firearm, that the gun was found in Ethan's bag at the time you were meeting with him. Are you aware of that?
I am not aware of looking at
If the gun was in his bag and you had opened his bag, you would have seen a gun, correct?
I don't know.
Now, that's about as dumb an answer as you can give on cross-examination. You're telling me that if you looked in the bag and there was a gun in the bag, you wouldn't have seen it? This is a guy who is essentially afraid of that answer, and for good reason, as I'll point out later.
Did you make any effort to find out what Ethan did have in the bag?
No.
Did you notify his teachers in the 3rd hour, 4th hour, or anyone in the lunchroom that you believed he might have?
No.
So again, here we have the counselor, who is the person who had the opportunity to interdict the shooting, if you will, by making a good, comprehensive mental evaluation of this kid, and he didn't do it. He didn't take any steps to notify anybody, and that, I think, is something that they will use quite effectively at closing argument. And again, this has not been admitted before essentially before the jury. This particular video has not been admitted before the jury. But much of this came in during the testimony of the counselor, and we just don't need to go through it again right here.
And you obviously didn't do that because you didn't think there was any reason to have to protect him in any extra way, correct?
No, I would want him to be with me.
Okay, so him being with people was what was important, correct?
Correct.
And that's why him going home alone and having his parents be working would also not have been ideal, correct?
Correct.
Okay. So one of the things that the state has pointed out is that the parents had the opportunity to stop this by taking the kid to, get counseling on the day that this all occurred, and they didn't do that. But it's pretty obvious here that the kid would have stayed at home, and that wouldn't have been good for him.
You testified a little bit about the parents and how they interacted with you, how they behaved in the office. It's fair to say that Mr. and Mrs. Crumbley were not parents that were frequently in your office. Is that correct?
Correct.
In fact, this was.
And again, that's a classic lawyer technique. You didn't have the opportunity to observe them, so you don't know whether their demeanor on that day was different than it would have been any other day. And she's really doing a much better job at this pretrial hearing than she did at the actual hearing. But in a minute here, we're going to see the testimony that comes in from this same witness when Mr. Crumbley's attorney talks to him, and I think that is one of the big keys in this case. Now, this is Mr. Crumbley's attorney, and notice the difference in the tone of her voice and the way that she goes after this witness. I think it's a distinction that you'll see a big difference between her and the young lady who was just talking.
Testified about your education and training as it relates to psychology. Is that accurate?
Counseling.
Counseling, okay. And you've worked with teenagers. You were a youth pastor previously?
Yes.
Okay. And so you've worked with teenagers for a long, since about 2009. Did I do that correctly?
Yes.
You have a lot of experience with teenagers. Is that fair?
Yeah.
And based on all of your experience with teenagers, based on your counseling, education, and training, at no time in your interactions with Ethan Crumbley did you feel that he was a threat to anyone else other than himself. Is that fair?
Correct.
So that's pretty powerful right there. So the fellow who was right there at the time had the opportunity to look the kid in the eye, had the opportunity to go through the backpack, had the opportunity to assess the situation, had the opportunity to assess the relationship between the parents and the child. He did not think he was a threat to anybody except himself. And that, I think, is a key finding. Now, later in the trial, we're going to hear from, or we did hear from, the Dean of Students. And the Dean of Students said the same thing. He did not assess him as a threat to any of the other students. And of course, the prosecution did get in some evidence on direct that harmed the defense. We'll take a look at some of that right now.
So when you ask more pointed questions, tell us what happened next and why.
His demeanor at first was very compliant. And as I started asking about the words and asking him to describe the words, his demeanor shifted towards more of a sad demeanor.
Okay.
He started sharing some things that had gone on in his life.
Like what?
He mentioned that a family dog had died recently. He mentioned that a grandparent had passed, that he was struggling with COVID and with school through COVID. And he mentioned that he had an argument with his parents about grades the night before.
Did he tell you that a friend of his had abruptly left the state?
He did mention that a friend of his had left. He didn't say the state, just wasn't attending school anymore.
Okay. Now, did you make a decision based upon your conversation with him to call Jennifer Crumbley?
I did.
You know, is that before or after you saw the original drawing?
I don't remember.
So the prosecution scored some points there. And, they mentioned that the parents, for example, were a little reluctant to come in and that they prioritized work. And they didn't want to take the kid home because neither of them could stay with them because they both had to work. And while in retrospect, sort of in hindsight, that looks like a really foolish thing, right? Almost every juror on that panel is going to be somebody who has had to work for a living. And almost every one of them is going to be somebody who's had a boss. And almost every one of them has had to be in a situation where they've had to explain why they needed to be out and why their kid made it necessary for them to be out. And that's not an easy thing to do. So when you have somebody who's 15 years old who possibly could stay at home, but you don't want him to stay at home, well, that's a situation that jurors are likely to understand. Now, let's watch as the defense attorney goes through some of the counselor's background here in her cross-examination of this witness, and let's see if she scores any points here.
What does it mean to be licensed as a school counselor, or what does one have to do to obtain a license?
You have to graduate with a degree from an accredited university and meet all the standards of the state of Michigan to become a school counselor.
And obviously you did that.
Yes.
Can you give us the example and some examples of the standards?
I have to meet the required trainings based on hours over a certain period of years.
Do you recall how many hours or?
Well, they're broken up into specific categories, but in totality, it's on top of the degree, 150 hours every 5 years.
150 every 5 years. And you just mentioned that they're broken up into categories. Can you just give us a quick idea of what these categories are?
Yep. Some are based on college. They have to be hours specific towards helping students get to college. Some are based on careers, and some are more general.
Are any of those based on or danger at school or discipline?
Those hours are not, but a degree in counseling is. I asked him what he was watching.
And you relied on the information he provided to you about what he was watching?
Exactly as I would if I asked him to show me the videos, yes.
I'm sorry, I don't understand what that means.
I was relying on him to provide the information, which would be the same as if I had asked him to show the videos.
Okay, but if you saw the videos, you would know specifically what they look like. You are instead relying on what Mrs. Crumbley's son says was on the videos, correct?
Yes, I asked him what they were, and he told me what they were, and I relied on the information he gave me.
When he told you what the videos were, the information you relied on, did he tell you where he obtained those videos from?
No.
When you were speaking with Mrs. Crumbley's son, it's fair to say that you and Mrs. Crumbley's son discussed whether he wanted to stay in school that day or go home prior to the arrival of Mr. and Mrs. Crumbley. Is that correct?
That did come up, yes.
And Mrs. Crumbley's son's position was, I want to stay in school, correct?
Correct.
My question is that something that you believe, that it would have been better for him to be around peers that afternoon versus being left home alone?
It's the judgment call I made.
I'm sorry, what was that?
That is the judgment call I made, was that I felt it was better for him to be around peers and people who are his age than to be home alone.
So what did our defense attorney do here? She essentially established that he is not curious. He did not do any independent investigation. He trusted what this child was telling him. And he still harbored a suspicion that the child might have an emotional problem related to possible self-harm. And yet, he felt it was more important for him to be with peers than to be home alone. So, at least with respect to the information that he likely provided to the parents, it was, your choice is take him home and take him to a counselor, get him some help today, or leave him here and we'll look after him. And I think she's done a credible job of doing that without saying that. And I have to give her some props there. I think that was the right thing to do in this particular case. So here's what I'd say. At the end of the day, the defense has one valid, viable argument to make for acquittal. Both the dean of students, who also testified, and the school counselor, the one with the background in psychology and counseling, determined that Ethan was a bigger threat to himself than anybody else. It never occurred to them that he might be a threat to the other students, even though he had a gun in his book bag when he was talking with the counselor, and the counselor never even looked in the book bag. The counselor was presented with a drawing of somebody being shot, and rather than think about it as a homicide, he thought about it as a suicide. So the defense, if they're going to be successful here, has to argue that if the guy with the psychology degree, with the counseling license, and the dean of students, if these two professionals did not see a problem, how can you expect a mom without those kinds of degrees and without that kind of experience to make the leap that he's going to be a school shooter? This is where the rhetorical art of a lawyer is most important. Miss Crumbley is not unsympathetic sitting in the courtroom. She's been crying. I think it bothers her that her kid killed these kids. She's never going to see her son again except through a plexiglass window, and she's never going to hear his voice except on a jailhouse phone. While she's lucky he's still alive because he surrendered and didn't get shot, she likely doesn't feel very lucky. Being a criminal case, it's going to all come down to reasonable doubt. So what will the instruction tell the jury? A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of the case. Did Crumbley know that her kid had the gun at school? No. Of course not. If she had, she would have taken it away from him. Did she have any inkling after meeting with him and the counselor that he was going to go postal on his peers? Again, likely she did not. Part of the state's case in the elements is that she had a chance to save those kids by taking her kid home that day. But so did the counselor. He could have sent the kid home. So did the dean of students. He could have sent the kid home. Both of them have degrees in education and a background in dealing with troubled kids. Neither of them saw him as a school shooter or a threat. Neither one. And this was after they saw him watching shooting videos and looking up bullets and drawing a drawing that makes it clear that somebody's going to get hurt. You're going to hold mom liable for this when the two people who the school district pays to keep students safe and make sure they haven't gone cuckoo for Cocoa Puffs didn't see it either? Isn't it reasonable to doubt that anyone but Ethan knew what he planned to do? In my opinion, they can make a pretty good argument for reasonable doubt here. Now, will they do that? We'll have to see what happens at trial. But I think they can make a pretty good argument for reasonable doubt. And I hope that they do. And I hope the jury has this question in front of them. I'm pretty sure the jury will reach whatever decision is in the best interests of both Ms. Crumbley being held accountable and basically the justice system. She's already been held accountable to a certain extent because she's had to pay for a defense and come into trial and go through all of this. There's some accountability there. Will she wind up going to prison? Hard to tell. But again, I do think they can make a case for reasonable doubt. At this point, I want to make a point of saying that I think it is important and necessary for people to stay in contact with their children and to assess their health, particularly their emotional health, on a daily basis. And one kindness that you can do as a friend or a neighbor or perhaps a friend of the child at school, one of his schoolmates, one of the things they can do is they can tell somebody, hey, this fellow has not been acting like himself lately. He's kind of sad. I'm worried about him. Maybe you should talk to him. Not everybody realizes when a red flag is warning, but that is a kindness that people can do if they suspect that somebody might be going through emotional problems. Many people are fighting a battle that no one else knows anything about. And when they fight that battle all by themselves, sometimes they lose. It's important for us when we can to try and help them win that battle. That's what I have for you today. Thanks so much for watching. Catch me down here at the beach again next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.